Hello, and once again, welcome to another episode in our series Million Dollar Breakdown, our biggest verdicts from the attorneys that won them. And today we are going to unpack the details of a $1.3 million verdict from Alabama. And here to discuss the case with us is Morgan & Morgan attorney Victoria Dye. Victoria, very
Hi.
good to speak with you today.
Thank you for having me.
So let's begin with a really quick outline of the accident that
Mhm.
resulted in this case.
Sure. So we had two clients involved in this case, a husband and wife, Robert and Rebecca Smith. They were driving down a two-lane road in Cullman, Alabama. This was in 2019. Another vehicle was traveling in the opposite direction, hauling a trailer. He was driving way too fast and lost control of the vehicle, crossed the center line, rolled over, and mid-roll, his car actually was in the air when it landed on top of our client's moving vehicle, and caused a pretty significant crash.
Wow. Was there a pre-trial offer on this?
There was. So a little bit of a twist in this case. The at-fault driver had minimum limits in Alabama. That's 25,000 per person and 50,000 per accident. They tendered their limits almost immediately. Our clients were responsible and had underinsured motorist coverage that they had paid for with State Farm since I believe the 70s. So they had been longtime customers and they had a good bit of coverage on that policy in the hundreds of thousands of dollars on the underinsured motorist. And State Farm did not want to pay. It took almost till close to the time of trial, and their top offer for both clients was about $180,000.
Wow. Okay. What more then can you share with us about your clients and perhaps let us know what their lives were like prior to that really horrific crash?
Yeah, that's a great question, and in fact, it was kind of the turning point or the emphasis in our case at trial. Robert and Rebecca were actually in their golden years, as we say. They were retired, so they were in their 70s, and actually, Robert was almost 80 years old. They were living in Cullman, Alabama, which is a somewhat rural community about an hour outside of Birmingham. They had both grown up in the area, had both separately and individually moved out to Texas, met each other there, and were married. And when they both finally retired, he was a security guard for a hospital and she worked at a hospital. When they finally retired, they moved back here and bought a little piece of land and had a little hobby farm, as we say. And so they spent their days outdoors. They loved to garden. And he cultivated a beautiful garden and they grew some crops just for their own kind of consumption. So they were rather active, although retired, and were excited to be back home and close to family members at the time that this crash occurred. And of course, all of that changed extremely quickly within the year. They had to sell their beloved farm and they had to move back to Texas so their adult daughter could take care of them.
Wow. This is really tragic.
It was.
I'm curious, what do you think were the most crucial factors for you in this case?
So liability was not disputed in this case, right? The at-fault driver admitted that the crash was his fault and his insurance company paid his policy limits. The difficulty here was proving up the extent of the damages or the value of the damages that our clients had sustained. Of course, in my opinion, and I always tell clients this, the value of your case is immeasurable, right? Nobody can give you back, money won't give you back physical health and well being or mental health and well being. But value is measured in these cases in terms of dollars and cents in accordance with what the insurance coverage is for the most part, generally speaking. Um, the challenge was convincing a jury that permanent pain and suffering is worth money. That is an abstract concept. There's no hard and fast number, right? It's not like medical bills, which are numbers that everybody can see and understand. So the challenge was getting the jury to understand that even though these clients were older, and as we all do, our bodies break down. Wear and tear happens over time to our bodies, but that doesn't mean you can't still be injured. And so we had a good bit of medical deposition testimony taken in the case and presented at trial to establish that even though there wasn't a surgery involved in this case, um, there were broken bones. There was a fractured sternum involved. And also, there was a torn rotator cuff that was non-surgical, but they still had pain and they had issues. And particularly, Mr. Smith's condition deteriorated very, very quickly, and he never recovered.
So in this case, how did you then approach jury selection? What sort of considerations came into play?
So the county where this trial was held is called Coleman County, Alabama. It is, as I mentioned, a somewhat rural county. There's actually a good mixture. There's a more populated area, but a lot of it is farmland as well. So it is an extremely conservative county, and that's saying a lot because we're in Alabama. There's a lot of conservative counties here, but this is up there with one of those very kind of solidly defense-oriented jurisdictions.
Mhm.
Um, so our challenge was starting in jury selection to go ahead and put in their minds, because we had an individual defendant. The uninsured motorist carrier opted out, which means the jury did not get to know that the underinsured motorist carrier was a defendant in the case, right? All they saw was an individual driver sitting at the defense table with his lawyer. And so the difficulty there is we're not allowed to bring up insurance if they opt out. We could not say that there was insurance. We could not tell the jury at any point that this individual guy sitting at this table is not going to be responsible for whatever verdict you render. So that presents a lot of challenges. You can't talk about insurance, so you have to present the case in a way where the jury understands that they've got to put on blinders, right? You don't worry about who's going to pay it or how it's going to get paid or when it's going to get paid or if it's going to get paid at all, ever. Your question is, what is the value of what they lost? And so our difficulty, knowing that we are going to have a very conservative jury pool, and we did, was to explain to them, put aside your biases and put aside your notions about lawyers and lawsuits. And we want you to get to know our clients and what they've been through and assign a value to what they've lost. And that was the biggest issue. And by the way, we ended up getting an all-female jury seated, which I've never had in my almost 17 years of plaintiff's work. Yeah, it was interesting to say the least.
Well, given that, tell us how you prepared for arguments that you assumed opposing counsel would use to undermine your case.
So again, a unique thing about this case, because there was no liability defense, is that early on, Irby Fisher, my partner, and I approached defense counsel for the individual defendant, right? Because when the UIM carrier has opted out, they don't get a say in how the case is presented at trial. They tried to, and we fought with them in pretrial motions. They tried to shape the way that the case was going to go, and we fought with them, and they were not successful there. But we approached defense counsel for the individual defendant and asked if they would agree to enter into pretrial stipulations, which is something the judge reads out to the jury and tells the jury, hey, look, here's the facts that everybody agrees on. You don't have to worry about these issues. You're not going to decide these. They've already been decided and agreed upon. And those were instrumental in shaping our arguments at trial, because we knew the arguments were going to focus solely on damages. And we also knew kind of what their arguments were going to be in that regard, because we'd already taken the medical depositions of the treating physicians in the case. We take those by Zoom because doctors, we don't want them taking time out of their day to sit at a courthouse all day and wait their turn to talk. So that's a courtesy that's allowed under the rules in Alabama. And we had already taken all the medical testimony. We understood and knew what the cross-examination was of those doctors because it had already happened. And so really the bulk of this case came down to how we presented it during the jury selection, during opening arguments, and during the opening statements and closing arguments. Mm-hmm.
I'm glad you bring up those closing arguments. They have their unique challenges. It's sort of where you get to tie up all the strings of the case. How did you prepare for those closing arguments?
Sure. So we use tech a lot in our trials. I think that visual aids, and especially technically correct and precise visual aids, are immeasurably valuable when you're presenting a case, especially one like this, to a jury where there's a lot of medical information involved. It's very technical. It can be a little bit dense, right? So we have a closing presentation that we like to build out and prepare. We use software on our iPads called TrialPad, and it helps us to easily present and kind of move back and forth between images and video clips and whatnot and graphics. But the biggest thing that we did, and Irby Fisher, my partner, who's masterful at this, and Mike Bowling, also in our office, did some of the closing presentation arguments. The other thing that we did, though, was we couched the pain and suffering damages, which are amorphous, right? There's not a hard and fast rule. It's up to the jury gets to decide how they're going to award it and how they're going to figure out what the number is. There's no formula. What we did was, the pull tab images of like, you want a job, call this number. We created a graphic of that, and it the job or the job qualifications were 24/7 pain and suffering, no breaks, no vacations, lifelong pain guaranteed, medical, all these kind of things that our clients have gone through. And we argued that what would have to be the hourly rate for you to pull a tab and call that number to take this job? Would it be minimum wage? Would it be something higher? Of course it would. I would never take that job, and probably for anything. And so that's kind of how we couched an example of the jury to start thinking about pain and suffering damages, and the value of those damages is in terms of an hourly rate, like an hourly wage. And we broke it down in different categories of wages and had a table up, and we did waking hours, which we calculated as 16 hours a day. And then we did 24 hours a day of pain and suffering. And that's how we presented those damages to the jury in a way that wasn't just, here's a big number, give it to us, right? We gave them we gave them some meat behind it and the reason why we asked that number.
That's an amazing breakdown to present. Yeah. So looking back at this case, were there any personal takeaways for you? Perhaps something that you learned from this case?
I think that the biggest takeaway in cases like this where, because we're seeing this more and more often, where the at-fault driver, their insurance company will pay their limits because if they have them, first of all. I also see a lot of uninsured drivers after COVID now. If the driver has coverage, it's usually going to be a state minimum policy unless it's a commercial case. And I'm seeing a lot more UIM carriers start to balk at paying out money that these clients they've been paying for this coverage. And in our case, for decades, they had been paying this same insurance company, never missed their premiums, never had an issue, never even made a claim, by the way, on their policy. So liability wise or otherwise. And they wanted to nickel and dime these poor clients, and it backfired on them. Fortunately for us, this jury in this very conservative county gave a really big award that quickly got around the legal community because it was very unusual for that county. But the biggest takeaway is, in cases like this where liability is not in dispute, the way that you humanize your clients and the way that you present what they've gone through, and particularly when it comes to pain and suffering and these kind of what I call amorphous or fluid elements of damages, is critically important. Making the jury understand that there's a real person on the other side of the table, from you in a deposition or from the defense lawyer in a deposition, or even at trial, is so important. And I say a deposition because our clients were still in Texas, by the way. They were not able to attend the trial live. And in fact, Mr. Smith, unfortunately and very sadly, passed away the morning of trial in this case.
So this must have been quite an emotional and taxing case for you.
Absolutely. It was unique in a lot of ways. And I was extremely proud of our team and the way we overcame. That could also be a negative when your clients are not present in the courtroom, but there's an individual defendant across at the other table from you, and the jury sees that person sitting there. It's easy for that natural bias or sympathy to creep in, especially because we can't tell them that there's insurance coverage that will be paying any verdict. So it was difficult, but it was very rewarding and satisfying to get that victory for them.
Super. Victoria, again, thanks so much for spending time with us and sharing your experience and insights on this case. Thank you.